Good afternoon, everybody. Nice to see everyone today virtually. And I'm going to be discussing for the next hour a topic. This is actually one of my favorite topics that I deal with clients, particularly in the area of healthcare law, because typically people, when they're doing contract negotiation, a lot of times it's people that are relocating, they're excited about taking on a new job. Sometimes it's people coming out of school, people that have a lot of experience. It's usually a situation where everybody's upbeat. And so I review a lot of employment contracts. Not only this one says employment contracts, the title is employment contracts for physicians and other healthcare providers. A lot of the concepts we're going to talk about today can be applied broadly. There are some specific regulatory issues with physicians and other licensed providers, but a lot of the concepts that we'll talk about, you can take these and apply them in many employment contract situations involving professionals, and particularly in the area of healthcare. So we'll jump in. If you have any questions along the way, drop them into the chat or save them for later. I'm always happy to field questions at the end, or at a later date if you want to contact me after the seminar. Here's a copy of our agenda that you see on the screen. We'll do a little introduction. We'll talk about some early negotiating points and go into the elements of an agreement. And most employment agreements are going to have very similar elements. They're going to have specific things that they discuss, and they're going to follow often a regular pattern. You're going to see some defined terms. I tell clients, when they read contracts on their own, of course, it's a good idea to have an attorney, but you can read these on your own. You see capitalized words or words in bold or in quotes, they're defined terms. Some contracts will have a definition section. Other ones will just have terms that are put into quotes and capitalized. Most employment and contracts, of course, you're going to have a term of employment. You're going to have your provisions for compensation, insurance, indemnity, and the insurance ones in particular, indemnity, are unique. Termination with cause provisions are unique. When we talk about healthcare, we'll dig through all of that. And we'll talk about some negotiating points and give you some tips at the end. So here's just a little statement about the introduction. So very interesting that we talk about the relationship between the healthcare providers and the hiring entities and the providers that provide services for the patients. I represent several healthcare providers. All of the ones that I deal with and talk to and represent, all hardworking, dedicated folks. I represent some that are now retired and have retired, unfortunately early, including my own personal physician a few years ago, who's around my age, because of all the administrative burden and all the crap that people have to deal with, candidly, outside of caring for patients. Of course, that's been in the news and events over the last couple of months with managed care and insurance companies and the profits they generate, hospital systems and administrative systems and so forth. I'm going to try and avoid most of the discussion on that, but the reality is when you're negotiating a contract, who you're negotiating with matters. Sometimes you'll be negotiating it with an employer. It may be another physician who operates a practice and is looking to bring on help. It may be a management company who operates or runs several offices that provide healthcare services. It may be a private equity group or some other type of larger entity. And I've had clients that have had different experiences with those types of groups. Of course, it could be a hospital or something related to a hospital system, a physician group affiliated with a hospital. All of those have their own different considerations. For one, if you are considering employment, is that who you want to work for? Are their values aligned with yours? What kind of situation are you getting yourself into? And it also may affect your negotiating leverage. In a bigger system, it may be a little bit more lockstep, meaning that your room for negotiation is smaller because you'll hear, well, this is what we do this is our standard practice, and it's what we did for 75 other physicians who came to us that were in this point in their career, and you fall into that line, and so we're going to treat you the same. If you're with a smaller group, one that has a little bit more autonomy, a little bit more flexibility, you may find yourself in a different situation. Of course, your negotiating leverage, and we'll talk about this, that will change depending on your experience and your skill set, what area you are in, and so forth. So little look at the types of agreements you may see as a healthcare provider. The two main ones and the ones we're going to focus on today are your employment agreements and your independent contractor agreements. So what's the difference between an employee and an independent contractor? This is an age-old question. The IRS has a set of, I think it's 20 different factors that they look at. Certain states will have legal authority. There may be case law on who's an independent contractor and who's an employee. I get asked this question a lot. There's a lot of assumptions. The one thing I will tell you is don't rely on assumptions. Don't rely on a bright line rule. Well, I understand that if the employee works their own schedule, or if the person works their own schedule, they're an independent contractor and not an employee. Well, that may be the case if it's somebody who can work whenever they want, not work whenever they want. But you may have a situation where somebody is expected to put in a certain number of hours per week or have certain tasks that they are supposed to complete. And depending on how much control the employer or the person hiring them, let's say it's it's an independent contract relationship, but the hiring company who hired that independent contractor exerts control, you may find yourself in a situation where somebody considers that to be an employment relationship. Why is that important? Well, as an employee, you have certain rights and certain obligations, such as making sure you comply with W-2 tax filings and wage filings and so forth on your taxes, and for the employer to do that as well. Certain benefits that may be available, overtime rules that may apply, and other requirements that may apply to employers in particular and not independent contractors. Your workers' comp insurance may be affected if you're an employer. I've seen a lot of these issues, and of course, this was in the news a couple of years ago with Uber and Lyft, with the lawsuits out on the West Coast of the U.S., out in California, where a bunch of folks sued to essentially gain status as employees. So, takeaway here is that it's not always a bright line rule that's going to say who's a independent contractor and who is an employee. Some other types of agreements, locum tenens, I look at those sometimes for employers and folks that are getting into those arrangements. Another big one that's not on the screen here that I've seen more are agreements to work. I suppose they would be independent contractor agreements, but they're a little unique. Agreements to provide telehealth services. Telehealth is a unique animal because you can do it virtually, just like we are here. Presumably, there's folks maybe all over the state or all over the country, some folks zooming in today to this seminar that are somewhere else in the country. And you have that situation with employment agreements now. I have one client in particular who is licensed in all 50 states and works exclusively now with a telehealth company and is able to provide services throughout the country. The rules when it comes to providing telehealth services, I don't need to go into those. It's separate from employment agreements, but just the general rule is that wherever the patient is where the services are being provided. And so if you are providing services, even if you're in Florida and hired by a Florida company to provide services to somebody in Missouri, it may be that you need to be licensed in Missouri. You need to double check that. I'm not giving legal advice here during the seminar, but that's the general rule. There are some exceptions. The exceptions if you have an ongoing patient relationship with somebody and they happen to be gone and you jump on a Zoom with them. If you see them typically in Florida and then they are traveling and have a question, well, you're not going to be necessarily need to be licensed in Massachusetts if they happen to have a question for you up in Massachusetts. But just be careful of that if you get into that arrangement. And then, of course, ownership agreements. And for folks who are looking to bring on, I just spoke to a client the other day that was talking about bringing on other providers, other licensed providers, and maybe bringing them on as shareholders or partners or co-owners in the business. You want to be careful when you do that. It's a great way to help grow your practice. It's a great way to help grow dedication and camaraderie and teamwork in the practice, but you want to make sure that you do it the right way from an employer standpoint, to make sure you're not providing equity to somebody who's going to leave and run off somewhere else and they still have an ownership interest in your business. So you want to have certain restrictions that apply, and that's pretty typical and arrangements for physicians and other professionals who become partners in the business where they're working, certain work requirements and employment requirements. We're not going to really get into some of these other agreements, but I just want you to be aware of the different types of things that you may see. Recruitment agreements, they have their own strings attached to them, and collaborative or supervisory agreements that may apply in specific settings, such as in emergency rooms or surgery centers and so forth. Moving on, we'll jump into employment agreements in particular. And first thing you got to do when you're looking at an employment arrangement is consider, is this going to be a good fit? Is this a place where I feel comfortable? How are your negotiations early on? Are your questions being answered? If you have, by all means, have questions and get answers to your questions. Figure out what's important. Geographic locale, of course, is important. Compensation, schedule, what type of work are you going to be doing? How much are you going to be on call? Uh, what's your, the big term I hear now is work-life balance. What's the work-life balance going to be? What's the room for advancement? What's the next step after you first get hired? Is there an option to have equity? Is there an option to have equity and ownership interest and have any control, any voting interest? How far is it away from where you live? How much are you going to have to travel? Are you going to have to go to different offices? Are you going to have to have privileges at certain hospitals, and what do those privileges require? Are there restrictions? Some hospitals have restrictions that you have to live within a certain geographic locale of the hospital if you're going to have privileges. You have to consider that. Do you like the neighborhood? If you want to move somewhere else, or your spouse wants to move somewhere else, that could create some issues for you. These are all things you have to think about ahead of time before you even agree to get into an employment or an independent contractor relationship, particularly an employment relationship. And then you dig into the contract itself. First thing I'll tell you, you get the contract, you look at it. I've seen employment contracts anywhere from 8 pages to 28 pages. There may be attachments, there may be other documents that are incorporated, such as hospital bylaws or some other documents, maybe rules and regulations. But you take a look at the contract, and the one thing that I always recommend for clients when I'm asked to look at an employment contract is I will ask them if they either have or can get a Word copy of the contract. A lot of times the contract is provided in PDF form. And so early, this tells me how amenable the employer is going to be to negotiate. So I'll suggest, hey, can you get a Word copy of this? So if we have any comments or proposed changes or suggestions, we can make those on a document. We put them in red line form, send them back over to the employer. Sometimes we get it, sometimes we don't. And sometimes I've had situations where the response that comes back is, we don't change our contracts. Well, so then what? Do you just sign the contract you have? You love the job, everything feels perfect about it, but they're not going to say, or they're not going to change the contract. It's still worth reading through it and probably having a professional set of eyes on the contract. Even if you can't change it, you want to know uh, what is the arrangement? What are, the obvious points? You're going to know generally where you work, your schedule, the term of the contract, and your compensation. What general duties are you going to perform? But somewhere in that contract that may have additional duties. What are the on-call requirements and what are the limitations? What is the right of the employer to change or modify rules and regulations? If it's a big system, how much notice do you get if you violated a rule? Under some contracts, it may say I can terminate you with cause if you violate one of our rules that we implement, and we could change the rules after you sign the contract. Well, you really want that to be limited to reasonable rules, and you really want a notice and an opportunity to cure any violation. You don't want some foot fault, minor issue, somebody makes a complaint, which can happen, and you never knew about it, you don't have a right to cure it, and now you're out of employment. What are the notice requirements? When does the contract renew? What's the term of the contract? When does it renew? Renewal points are fantastic opportunities to renegotiate your contract. So you want to calendar the renewal, and you want to calendar some time ahead of the renewal to be ready to give notice. You need to understand under the contract, how do you give notice? What are the specific requirements? So even if it's not negotiable, it's still worth taking a look at the contract itself and maybe walking through it with a professional, understanding your insurance and other items in the contract. So part of your due diligence, obviously, I'm an attorney. I look at these for clients. I advocate using advisors, not only attorneys. I often send people to other, insurance advisors. If you're required to get insurance, I have somebody that I routinely refer clients to discuss insurance coverage. Tax situations, I'll suggest the client speak to their accountant or other tax advisor. Um, Obviously, other things you want to look at are, the what type of employer, I talked about this earlier, the patient demographic, what are what's the long-term plan for the employer? Is this somebody that you can have a career with, or is this a stepping stone to something else? Um, Ethical and religious directives, we're seeing that more in contracts. Where I am in Central Florida, we have, of course, Advent Health, formerly known as Florida Hospital, and a lot of their employment contracts state right in the contract that they make no, there's no hiding the fact that they are trying to promote the Adventist church, and they've stated that right in their contracts. As I read some of the contracts, the physicians or other folks who are employed by them understand that part of the mission is to advance the directives of the organization. So these are all things that you want to be aware of. And as you go through your due diligence, you're looking at certain items about the employer. The employer is looking at certain things about you. Of course, they'll look at your education and training. They'll potentially ask for references and make calls on those. A lot of folks are afraid to give a reference because they're afraid of some type of blowback if they give a reference that's not good. I've been called, not obviously not on for physicians, but for other lawyers, I've been called on references. Typically, it's great if I have a heads up and know that a call is going to be coming. That usually means that it's somebody asking me to give a reference because we've had a positive experience. Um, so, I'm happy to give a positive reference. I'm a little more reluctant to say something bad about somebody. I think most people understand, probably look at things similarly. I talked earlier about, who are the parties, who's the employer to the contract. That's an important element. A hospital contract is going to be different than a private practice contract. The private practice contract for a small employer, maybe only one other, one physician or just a couple providers, that's going to look different than a contract with a large group that's got over 100 providers and several offices and has a multi-state practice. Um, and as I said earlier, you had the comment here on the slide, your negotiation leverage is also often going to depend on the type of entity, the size of the entity, and your own experience and track record. Some providers have created such demand, they have a track record of performance that makes them very attractive, and they're going to be able to negotiate much more favorable terms, obviously, than somebody who's just coming out of school. When you're looking at your first regular employment, that's probably the toughest time to negotiate, and even that will depend to some degree on who you're negotiating with, what uh, what practice you're in, of course, um, and really just how well you understand the arrangement and are willing to ask for things that maybe you haven't thought of. We'll talk about some of the specifics in the next few slides.
Kirk, we have a question.
Yes,
So
let's
this
do the
one says,
question.
how do you negotiate for moonlighting or teaching while your contract says you cannot work anywhere else?
Great question. Yes, so contracts often do have language that restricts where you can work outside. So two things that I see often, and they sort of interrelate. One is your moonlighting question, doing work somewhere else. So most contracts, especially contracts for employment, off independent contractor agreements, it's a little easier. If I see something like that, I'm inclined, if I'm representing somebody, I may even jump on a call and say, hey, this is an independent contractor. How much do you want to control them? Because you're not their employer. You may be getting some issues, and maybe I try to use a little bit of negotiating judo with them. If it's an employer, tough to negotiate. I've had clients get in trouble. Often what they ask you to do is disclose any outside employment that you have. And there's a good reason for that. If I'm an employer and especially let's say I'm a hospital system or let's say I'm a university system and I have somebody who's working and they want to do outside work. They want to do telehealth work or locum tenens or something else. Um, there's potentially liability. If I'm paying for the insurance for that employee, I've got to worry about anything else that they do healthcare related. What I often see is that if it's not healthcare related, if you just you want to do volunteer work or work or be on a charitable board, or you want to even do charitable work maybe in healthcare, but it's not for pay, um, teaching, writing, expert witnessing, those types of things, it's really going to be a negotiation. You need to identify it ahead of time and say, hey, these are things that I do or I plan on doing, and how does the employer feel about it? Some employers aren't going to like it and they're not going to allow it. Others may. As you're there longer, if you're there for a year or a few years and you develop a good track record, that's why it's so important to understand when the contract renews. If the term, often you'll see language that'll say the contract goes for a year and will automatically renew unless either side gives notice not to renew at least 30 or 60 days or 90 days before the end of the term. Well, if that's the case and you're starting a contract on March 1st, you want to calendar the end of December, just put a note in your own, whatever you use, Outlook or whatever, and put a note in that calendar to look at the contract. All right, is now the time that I want to renegotiate. Maybe I didn't get everything I want the first time. Hey, now I've established myself. I'm a good soldier for the company. Next December, I say, I'd love to stay here. I want to stay on. Everything seems great, but I also want to do this doing other healthcare work as an employee is going to be often verboten. Most employers are not going to like that. Um, Doing something else that's unrelated, and I talked about the IP and other developing intellectual property or developing property more and more now with the way technology advances so fast and technology in healthcare. I'm seeing clients who are asked to either want to be directly involved in a product or have been asked to be advisors in a product, and that could be anything from an app to an actual physical product, something that makes the practice. I'm thinking of one in particular. I don't want to say anything because it's confidential, but something that makes the practice easier. If that, often the contract will say either there's a risk that you can't do that, or anything that gets developed while you're employed belongs to the employer. So you want to be sure to carve that out. You don't want to be working on an app and the app takes off and then the employer finds out about it and says, hey, well, you are an employee while you develop that app. It's our product. Now the issue there is going to be that you keep very clear records and keep a very clear distinction. If you're working on this app or this product or something else, and you're developing that on the employer's time or using the employer's resources while in the office or in whatever your work location is, the employer's kind of a stronger position and hey, that belongs to me or I have rights in that. If it's totally separate and there's a total clear delineation, you're going to have a better chance to take a position if that's yours separately. So the moonlighting, very tough as an employee to do that. I really only see that in situations where you're an independent contractor, and you're not really expected to work full time. You're maybe doing emergency room coverage, and you're doing 50 hours a month. So obviously, you may have another position. If you're a full time employee, they're going to want your full time dedication. I hope that answers the question. But the answer is how do you deal with it, or the answer to the question of how do you deal with it is you certainly need to disclose it and discuss it and figure out the optimum way to do that. It might be when you're first negotiating a contract, or it might be on a renewal, in which case you have to put off that moonlighting until next year and say, okay, when I come up for renewal, I want to do this and see what kind of feeling you get from your employer. You can also do it midterm, depending on what, some contracts have an absolute, right to walk away. So you can have termination without cause provision. Either side can execute typically on something like a 90-day notice, if that's the case. But you also need to be aware of the potential restrictive covenants. Are there covenants against competition? Are there covenants against solicitation, using property of the employer? And so those are things that you need to consider as well once you sign the contract. If there's a follow-up on that, I'm happy to take it. I love getting the questions, and that's a good one. It's one that comes up quite a bit. And I've had at least one client over time that lost a really nice job because of some outside work that was that the employer thought was not properly disclosed. So that has been an issue. All right, so we'll pop along here on the slides. Uh, you see some of the requirements, obviously, that the physician or other professional is going to have. It's not just going to be serving patients. It's going to be, a lot of administrative duties. Billing is an issue. Dealing with, if you're in a hospital or a group setting, there may be staff issues that you are expected to get involved in or sit on a board. A lot of bigger systems especially want their professionals not only to see patients, but they want them to be out doing other things, interacting with the public. So just be aware of what your requirements are. Of course, on-call duties are a big issue, and that's a question that we get a lot is how do I limit that? A lot of employers are not willing to limit, put limits in a contract on-call. And hear this on the next slide here, but from there, you really have to take a look at, if you can't get any limits, you got to get some experience. You got to figure out, okay, what's happening? Maybe talking to other employees, other people who've been in a similar situation. A lot of this is practice specific, of course. But if you're going into a relationship, let's say you're going into a practice and there's 4 or 5 other professionals, providers that are there. You're the young new person, and the other providers are all half out the door anyway. We see this not only in healthcare. We see this in law too. You have a few people who've been there for a long time. They've generated the client base or the patient base, and they're ready to sort of retire. They want to step away and spend a couple extra days a week playing golf or doing something else. Well, a lot of the load and the burden is going to fall on you. Is that okay? Some people may like that. It's okay. I'm willing to. I want to work a lot. I want to get the experience and build up my own relationships. But that probably means you're going to be spending a lot more time dealing with being on call and having requirements to go beyond just regular office hours. I'm going to turn now to go to this next slide here, physician representations and requirements. So every contract is going to require the physician to represent, and the employers usually will verify this. You have a proper license, you have DA registration if you need that, eligible for board certification. I've seen unique situations with international, with folks coming from overseas where there's it has nothing to do with their competency or their ability to practice, that there's just some issue or a glitch with their credentials where they're not able to obtain board certification for certain certifications. So if you fall into that category, take a close look at this and call it out. It won't necessarily mean you can't have a contract. And in fact, I think of that because of one person that I helped negotiate a contract where it was just known this physician can't get board certification in this because of wherever their education background was, they come from overseas, no problem. But we just need to carve that out, because if you make a representation and later can't fulfill it, or later turns out that representation was untrue, that often causes a bigger problem than if you just disclose at the beginning. Some other things are going to create problems. Obviously, if you can't get credentialed with an insurance company that the employer works with, that's going to be a problem. If you can't get privileges with a hospital the employer works with, that's going to be an issue. But take a look at this list. These are the common things you're going to be required to represent and warrant that are going to be true, not only when you sign the agreement, but usually there's a provision that says, hey, if any of this stuff changes, if you are threatened with something or something comes up, you need to disclose that and let the employer know. They also generally have a requirement or often need to evaluate that, at least from a legal standpoint, to see if they need to let the insurance carrier know, because oftentimes there's requirements to let the insurance carrier know if there has been a threatened claim, even if it hasn't been asserted. Working conditions. This is part of your due diligence as the employee, and you want to try to get have this as clear as possible when you sign a contract. Of course, you'd like to know where are you, who's responsible for setting your hours, setting your fees, bringing patients. Where are you going to have to provide services? You're going to be in multiple offices or just a single office? Who do you report to? What type of support are you going to have? Who are the payers? What type of patients are you going to see? Who's going to handle some of the administrative issues? Who's going to handle record keeping? Who's going to handle billing and collection. That's a huge issue in a lot of with a lot of folks that I deal with. Responding to records requests from payers after the fact and responding to audits and audit document requests. One advantage to being with a big group, of course, is that they often have their own department that deals with that. But you have less say over it. So, if you have a department that deals with that and they say, okay, we've decided this issue has come up, we're not going to challenge the issue, you're going to have to live with their decision. If you're in a smaller group or if you have more autonomy, maybe you get to decide what you challenge and whether or not your bill for something ultimately is paid and remains payable by the third party payer in particular. There's some additional legal issues that come up in connection with contracts. This is what often makes a lot of this makes physician agreements unique from a lot of other professional agreements. Obviously, there's restrictions on fee splitting, restrictions on referrals. There's fair market value compensation issues that come up with physician contracts. If you're negotiating with a hospital system, they're often going to have a certain band in which, based on what you do and how they can bill and your experience is going to dictate what your range of compensation can be. So you're going to have that limitation. Um, uh, Corporate practice of medicine, that's essentially, that can practices be owned by anybody other than licensed providers. Some states like Florida, the corporate practice of medicine doctrine allows companies and non-physicians to own as long as you comply with specific requirements. Non-physicians can own practices. Other states are more limited and have restrictions on that. And you're going to oftentimes you receive a little bit of education, but you're going to be often subject to reps and warranties as well that say you'll agree you have not and won't violate the Stark law. Stark is it's a gotcha for physicians, especially new physicians. And if you're an entrepreneur, you got other business ventures, you can't make referrals anywhere else where you may have a financial interest or even a relative has a financial interest. So that can tend to be a gotcha for folks. All right, bouncing right along here. Compensation options. Obviously, this is the part that people often focus on pretty early in the negotiating process. You want to know, how are you going to be paid? What are you going to be paid? How often? How is that going to change year over year? How much of that is salary? How much is bonus? And other types of compensation. Um, you can have signing bonuses, you can have performance and productivity bonuses. You can also have expense reimbursements and other things that get paid. I've seen signing bonuses initial, I've seen annual. If you're with the company and you stay with the company, you get a bonus. And of course, if you become a partner, have an equity interest, you then could have additional compensation in the form of distributions from ownership, from the business actually performing well that you have an ownership interest in. Here's what I'm going to say for bonuses and compensation structures that aren't straightforward. If you're not getting X amount per week or per month or per year, anything that's formula based, walk through it carefully with the employer or the HR department or whoever is responsible for it, and make sure you understand it and use examples. And I like sometimes examples in contracts. You have a formula. We often see the formula is based on an hours, how many hours the physician has been able to bill and collect for. Have a formula example, for example, here's a scenario, and attach that right to the contract or put it in the contract. Sometimes you can say, example attached as Exhibit A, and just ask the employer to attach that. If they won't attach it, at least keep the example, because later you have a written contract. The written contract is going to have something called an integration clause. It says everything's in the contract that we agreed to and there's nothing outside. But if there's an ambiguity in the contract, if later you're like, look, I understand this to mean this, somebody else looks at it, and by the way, this happens all the time. For attorneys, it's our job to be able to identify ambiguities and make arguments. That's why there's lawsuits, oftentimes several breach of contract cases where parties have a different interpretation over what a specific provision means. If you have an example that's maybe been circulated by email or something that's been provided, and you can pull that out later, you could try to make the argument or have your attorney make the argument that, hey, this may be ambiguous, but here's an example on how it applies, and then make an analogy to your own situation. So I always recommend trying to get clarification, make sure you understand how you're getting paid, um, and it's very clear to you, and don't sign the contract until you understand that. All right. Other compensation issues. So certain government actions. So a lot of contracts for healthcare providers will have some language, and I usually put this in there that if for any reason there's any government regulation that says that there's a problem with our relationship, the parties agree to negotiate in good faith to correct it. A government entity comes in and says you can't pay that much because it's beyond fair market value and it looks like a potential kickback because you brought this physician in because of the referrals that your system's going to get. You can't pay that much because this is a nonprofit employer and they can't pay too much because they have to meet certain requirements for a nonprofit organization. There could be other issues that pop up. You can't, some restriction. If that comes up, rather than having the contract go completely out the window, have a provision. You'll often see a provision that says, hey, we'll agree to negotiate in good faith and try and put this back together. And if that fails, then we'll terminate the relationship. And so I've seen that. I have it in my own contracts, so it's not uncommon. All right, let's look at some other stuff beyond compensation. This is where it really gets interesting because it's stuff people don't talk about or focus on a lot. Insurance is a big issue, and it's important uh, for physicians and other professionals to understand the different types of insurance. It basically falls into two different types. One is you have claims-made insurance and an occurrence-based insurance. And here's the difference. I'm working, and I worked all through 2024, and now there's a claim in February or March of 2025, a couple months later, about something that happened in 2024. If it's an occurrence-based policy, that should be covered. If it's a claims-made policy, it won't be covered. It won't be covered because the claim wasn't made during the time that the policy was in force. Obviously, an occurrence-based policy is a richer policy because it covers the entire time of the relationship or during when the coverage was in place. Or a claims-made policy, just like it sounds, you have to have two elements. You have to have the claim itself and the claim being made or asserted during the time that the policy is in place. That's a big difference. Most insurances are claims-made insurance. Most that I see, especially if they're employer-paid insurance. So you need to understand that. Why is that important? Well, one, are you going to be covered for things that you did while you were with the employer after the employment relationship ends? That's where tail coverage comes in. Tail coverage is coverage that is designed to cover you after you leave the employer for things that may have happened there, but the claim hasn't been asserted yet. So if you have claims-made coverage, you're going to have to probably have tail coverage. And if you go to another employer, this will be an issue. You need something that's going to cover you. The new employer doesn't want to cover you for things that happened when you were at your last employer. They don't want to get drug into that. So you have tail coverage. Oftentimes it makes the most sense to get tail coverage from whoever was providing the coverage during the time. Sometimes you can get a new employer to help pay or reimburse you for tail coverage from your prior employer. Sometimes you can tie the two together. Just be aware of it. And be aware that sometimes you're required as the employee, depending on the circumstances under which you departed or left the employment relationship, you may be required to pay that. So if it's what I like to see at a very least is if the termination is termination without cause by the employer. Hey, we're having a drawdown, a reduction, a forced reduction. We need to let some people go. We need to let you go. We want the employer to pay for that coverage. If the employee opts to leave, or if if the employee gets terminated with cause, your contract could require you to pay for tail coverage, not only for you, but for the employer as well. So you need to be aware of that. You certainly don't want a contract that allows the employer to terminate the relationship whenever it wants, and you have to pay for tail coverage. So that's definitely an issue of negotiation. By the way, same issue applies to restrictive covenants. I like to have restrictive covenants, and we'll talk about that in a few slides, but I like to have restrictive covenants limited so that if the employer terminates the relationship without cause or within a certain period of time, have some limitation so they can't just hire people, get them under non-compete, non-solicitation covenants, let them go, and then now you're hamstrung for the next 2 years, and you can't work within 5,000 miles of the employer or whatever craziness it is. Uh, Other insurance issues, obviously, your own insurance benefits. Oops, sorry about that. Insurance benefits are something to look at. That's part of your compensation policy. And for health insurance, is it through a group, or is it a self-funded? If it's a big group, it may be an employer-funded policy. So you want to understand uh, what you have there. Life insurance, if you become a partner, I just went over this with somebody too. If you become a partner in a practice, it's not uncommon for partners in a practice to have life insurance that covers the partners. And often you'll hear that called a key man policy or something similar to that. The purpose of that is so that the practice takes out insurance. Typically, how it works, the practice takes out insurance on the individual's life, the partners. And so if the partner passes away, if something, maybe even disability, if something happens with the partner and they can't work anymore, the insurance policy pays the practice, not the partner. Why is that? It's because, let's say the partner passes away. Now the interest goes to the estate. Let's just say it's a spouse. Now you've got a practice with partner physicians, equity owners, and you've got a spouse, somebody who's not a licensed person, who's now got an ownership interest. So you need to be able to purchase that ownership interest. So you don't have to come out of pocket. Um, the idea is, and so that a practice doesn't have to come out of pocket and pay for that interest. You use the insurance money, the proceeds from the key man policy, to pay that interest. So the spouse has some payment and recovery, and the equity stays within the company. So that can be important. If you have questions about that, I always recommend you talk to a good insurance professional, and I'm happy to make referrals for that if requested. All right, next slide. Uh, Other basic elements of employment agreements, retirement plans, other benefits that you need to be looking at. Is there a 401k? Is there a SEP IRA? Is it something else? Do they have a pension? Sometimes big groups, hospital groups may have their own unique plans. Is there a chance of becoming partner in the group, and will that change? You want to know your vacation, your paid days off. Usually what we see now is just PTO, paid time off. You can use it for vacation, sick days, whatever it is. You want to be sure you can use it, by the way. If you go into a group and you're talking to other people work there and people say, oh, we never take vacation, that should be like a red flag. Like, why aren't they taking it? What happens? Do they get paid out for it? Does it roll over to the following year? What's the employer's policy? You want to know, like, if I don't get a chance to use this, what's going to happen? Is it use or lose every year? That's not a great deal, especially if it's use or lose, and every time you want to take vacation, you're a low man on a totem pole and you can't go. So understand that. Term, uh, commencement date, initial term. So I mentioned earlier, a lot of contracts will have a start date for when the contract commences. It'll say this contract runs, some of them are multi-year and some of them are annual. A lot of them are going to be annual because of regulatory issues and kickback and so forth to get exceptions with the employment contracts. You'll see it's going to be at least for a term of a year. So it'll often say the contract runs for a year. At the end of the year, automatically renews. That's usually the provision. Understand that. Understand if it's an automatic renewal or if somebody needs to give notice. Then that's your initial term, and then you'll have successive terms after that. And again, I'll throw another reminder out there. Put the renewal time and the time that you have to give notice on your calendar to pop up every year. I like to have even 2 reminders. If your contract runs January 1 to January 1 and you have a 60-day notice, have a reminder in September and October every year, because it's not just about if you want to leave. That is your opportunity if you want to try to renegotiate, because your leverage is, hey, I want to stay, but I'm not happy, or I'd like to renegotiate this point. And in the background, that I have a right to leave right now if I can't get what I want. Termination provisions, we talked about a little bit about without cause. Of course, for cause termination, most employers will have some language in here that says if you lose your license for substantial misconduct, there's going to be an employer right to terminate. What we want to do when we're negotiating these is things like this last one down here, material breach of agreement. If you are if you are in, what's a material breach? Well, we don't want it to be a material breach. Some will just say if you breach the agreement, if you breach any rules and regulations. You want to know what those are. you want to have notice, and you want to have an opportunity to cure. It could be, well, so-and-so doesn't like the way you talk to them, so you violated the employee relations rules and you mistreated staff, and you're going to get fired. That seems a little extreme. So you want to have notice and an opportunity to cure. And what I like to negotiate is not only notice and an opportunity to cure, but if the cure can't be completed for reasons outside of your control within the cure period, which may be 15 or 30 days, a right to reasonably extend that cure. Where does that come up? Let's say you need a particular continuing education requirement. You need a particular certification, but they're only issued every 60 days. You've done everything you can. The ball's not in your court anymore. You're just waiting on some other agency, and you have to get to the time frame, and that time is 60 days away. Well, then you would ask to extend the agreement so that you could come into compliance for that. Just again, it's usually for like a ministerial task that needs to be completed. These are things that we typically look at and want to negotiate into an agreement when we're looking at them, and that we don't often get much pushback on, quite candidly. Other ways to terminate, of course, termination without cause. And I represent employers, and usually if we can terminate without cause, especially if the results are the same, we want to do that instead of terminating with cause, because that tends to make people get defensive and causes fights. And if we don't want to cause fights if we don't have to. But I will, when I'm negotiating these for employees, often try to modify things like your restrictive covenants post-employment based on the way the relationship was terminated. If it was terminated without cause versus with cause, obviously. Uh, Sort of the next, similar point on next one, equitable walk away. If things aren't going well, can you leave? And what are your restrictions post-employment? Are you going to have restrictions on your ability to practice and work somewhere else locally within a certain area? Can you work with the same people? Typically, non-competes are one issue. Of course, they're subject to a lot of litigation, a lot of dispute over how enforceable non-competes are. Florida likes them, but there's still certain requirements to enforce a non-compete. Non-solicitation to me is a bigger deal. Employers don't want to hire somebody, bring them into the practice, introduce them to the staff and the patients. That person leaves, and then they start poaching the staff and patients. That, in my view, that's just wrong, and people shouldn't do that. Go build your own practice. But I'm not as big a fan. Most people who know me know I'm not as big a fan of non-compete, overbroad non-compete restrictions. I do draft them, and I have dealt with them. I've litigated them. But I like them to be reasonable, and I usually ask the employer, what are you trying to accomplish with this? What's the goal? If it's not obvious to me, we look at that. Post termination commitments. One common one, of course, is the insurance. Another one is completing any records that are required of the employer, making sure all the medical records are in good shape when you leave, so the employer can get paid. There's also typically a post termination covenant or agreement to cooperate with respect to any claims or any complaints that are made. If something happens and claims are asserted against the employee and or the employer, you want some type of covenant that everybody will cooperate to deal with those. You'll also see some indemnification language, usually in contracts, and we'll talk about that in a few minutes. Looking at the schedule here, I want to make sure we get our slides in.
Let me just give you a quick
Yeah,
question, Eric.
fire
So
away. Yes, sir. Yeah,
you
let's do
talked
it.
about tail coverage. Coverage is provided by the employer, or does the employee have to buy it?
Great question. Depends on what your contract says. So tail coverage, this is a big issue, and it could be like, I have some clients who work in it's a highly specialized area. They're in a big group, and we were looking at this, and they were looking at leaving and had to get tail coverage. It was like 60K, like $60,000 for tail coverage. That they were required to provide. So it was a big negotiating point as they were exiting this. It was a large multi-state practice. Um, you have to look at the contract. Sometimes the contract has the employer paying for it. Sometimes that is the employee. Sometimes it's silent. Sometimes it depends on the terms under which you left. If you leave due to the employer, for without cause, but the employer has asked you to leave, or if the contract just winds down, maybe the employer pays. If you leave with cause, or if you leave based on the employee giving notice, maybe you have to pay. It's totally subject to negotiation, and I encourage people to take a hard look at that and understand it when they sign the contract and when they're exiting. Uh, Other post termination requirements, we talked about records, notification of patients, repayment. Sometimes if you leave, you have to repay certain bonuses, or certain, if it's an annual bonus, it's paid, or moving expenses is another common one. By the way, I've negotiated and gotten employers to pay the employee a reimbursement for legal expenses for reviewing the contract. So I've had situations where I've gotten myself paid for, and I don't think it's a bad idea for employers. I'm going to tell you why. One of the most common arguments that you're going to hear if you're an employer and you go to enforce a contract, such as a restrictive covenant, the employee is going to say, unequal bargaining position, it wasn't fair, I didn't understand it, they had an attorney, I didn't have an attorney. And we write language into contracts that covers that, but some courts buy it, some don't. And then one of the best arguments that the employer can make is, hey, they had their own attorney. And sometimes the person gets their own attorney, but if they don't, if the employer says, hey, I provided you a stipend to go hire a lawyer to sign this, don't come back and tell me you didn't understand it, or it's not fair, or you don't think that this should be enforceable. You had your own counsel or the opportunity to have counsel. Not only that, I paid for it. I think that's a great argument. It's a very inexpensive insurance policy against having people argue later that an employment agreement's not fair. Not a lot of people do it, but I have negotiated that in for employees, and I wouldn't fault employers for including it. I've done an entire webinar, seminar. I might do that again because this law has been in, been out with the FTC. We've seen different things over the past year and a half. I've done a whole seminar on restrictive covenants, non-compete, non-solicit. I just wrote a contract for somebody that had what they call, the FTC calls these trap agreements, training repayment assistance, training repayment obligations. Essentially, somebody comes in, they get trained for several months, and then they leave. The employer says, hey, we trained you up. We spent 3, 6 months training you, 12 months training you, because we want you working with us for 2 years so we can make some of that back. If you take all that training and leave, we don't make any money and it costs us money. You can write those into contracts. Typically, you won't see those for physicians, but you'll see them for other professional, assistant providers and so forth. Um, you can write them in there. I just wrote them for somebody. I wrote it in a way I think is totally enforceable. So that's another way to try and keep people, or at least get reimbursed for training. One of the big issues with non-competes is you have to show a legitimate business reason for having the non-compete, and it's often specialized training. That's what we often see. So the non-competes need to be reasonable for duration, geographic scope, and the need to protect business interests. My favorite non-compete is one that I looked at. It was a big hospital group. Said if the physician left, they couldn't work anywhere within, I don't know, it was 60 miles of any location where the hospital group had a presence. And essentially, my physician that lived in Central Florida would have to move right on the banks of the Okeechobee, of Lake Okeechobee, or up to upstate Western North Carolina. That seems a little extreme to have to go that far in order to continue to practice, especially because that particular person was in a practice that wasn't really making referrals and had their own physician relationships. It was really a practice that relied on referrals within the practice already because of how specialized it was. So it just didn't seem to apply. Indemnification. This is a big issue that can be, negotiated and subject to a lot of back and forth in contracts. What's your obligation to indemnify the employer and vice versa? What I usually like to see with indemnity is somebody makes a claim against you and you can drag me into it, or somebody makes a claim against me and I say, hey, this was partially the fault of the employer. I didn't have proper support, the conditions weren't right, somebody else created this issue. I like to see these equal. I like to see equal indemnification, mirror provisions generally for the employer and the employee. If I see mirror provisions, I figure the employer, if I'm reviewing it on behalf of the employee, my quick check, and this is other contracts too, that I look at leases and other things. One party's not going to make the provision so overreaching. And so if it's a mirror type provision, you're usually not going to draft it too extreme. It's going to be pretty fair. I mentioned earlier, on-call requirements. Performance reviews are sometimes important. By the way, when with reviews, if you're leaving and you're leaving under less than ideal circumstances, information for physicians gets reported in the National Practitioner Database. You can sometimes negotiate on the exit the language that goes into that database, so it doesn't really have as big of effect on your career. So keep that in mind. With small practices and younger physicians and other professionals coming out. By the way, nurse practitioners, I've several clients in that area as well. So I say physicians, but it's really other professionals. Um, the consideration to become an equity or an owner in a business can be a big deal. Find out, I talked about this earlier, when you're negotiating and before signing the agreement, who are you going to answer to? Are you answering it to a service organization at somewhere else? Do you have a person that you call? Do you have a department that you call? Are you dealing with the person who's making the decisions? Are you dealing with somebody every time you ask, they're going to say, oh, I got to go talk to somebody else? That has a big difference. It's similar. I can use the analogy of law. I've worked in my legal career for a big law firm, and I had a really good experience. I worked for a big, really big, international law firm. I didn't like that as much. The people were super nice in my group. I just didn't like that big conglomerate. It felt too disconnected, and I did not particularly. It wasn't for me. I was in a small firm, and from that firm, I still work with four attorneys, five people from that firm that I've worked with for almost 20 years. September will be 20 years, so it's been 19 and a half years. And then now I've had my own firm. That's been a good experience for the last little over 10 years. So, what do you want now? And what are you looking at in the future? uh, you know, other intangibles, the chemistry, it's sort of along the same line. What's the vibe that you get when you're talking to everybody? Some folks are just looking to hire another cog in the wheel. Some places may want to sit down and have dinner with you and meet and talk and find out, how much of an interest do they take in your career, and how much do you think you can advance your career working with this particular group? Is this going to be something that's rewarding, something that you enjoy doing, and are you going to like the people you're working with? Here's a little note on choosing legal counsel. You can go it alone. Hopefully this seminar maybe is helpful for some folks. But I typically I'll look at have people contact me. I enjoy looking at contracts. I mark them up. I kind of do it in a very, I do a lot of them. So I look at them. I just mark up on a PDF of the document, sit down, have a consultation with folks, go over it before we really start digging into details. I'm able to do that, I think, on a pretty reasonable flat fee. That's what I usually do. So I give people a flat fee. I'm like, this is what it's going to cost. We're going to sit and go over it. We'll get on a Zoom just like this, face to face. I'll run through, answer all their questions. I think it usually works out pretty well for the folks who I'm doing this with. Again, because I like this. I see a lot of them. I focus in on things that I think are going to be important for the employee, things that are going to be important for them. So just make sure if you have somebody doing this, it's somebody who does it on a regular basis and they're qualified. And for negotiation, I usually ask people, what are the most important, you may not get everything. What are the most important things? And let's focus on that. I like this, bullet, don't enter in anything that looks like indentured servitude. Don't do it just for the money. I know it's tempting. Don't do it just for the money, because it won't be worth it. Backdoor options. Let me tell you one other thing. There's different philosophies. I got 2 minutes. I'm happy to take any other questions too. There's different philosophies on ambiguity in contracts. My partner, who's very bright, does a lot of contracting. There's a lot of very complex type stuff, and a lot of folks fall in his line of thinking. There's nothing wrong with this. I want everything clear in the contract. It should be clear before we sign it. In my view, let's go back and talk about your bargaining position and your leverage. If you're coming from a low leverage, low bargaining position, and you're negotiating a contract, then there's an area in the contract that's got some ambiguity in it. I don't like ambiguity in compensation, by the way, besides compensation. But let's say that the post-termination covenants and tail coverage and things like that have some ambiguity. Sometimes I like that ambiguity. People will say that that's a mistake. It should be clear. The reason I like the ambiguity is because if we go back to the employer and go back to the party who drafted the contract, usually the employer, and say, hey, there's an ambiguity here. We want to clarify it, and we want to clarify it in this way, and it totally advantages us. The employer's going to say, oh, no, thanks for pointing out that ambiguity. That's not what we meant. In fact, we meant it this way because we want to be tougher on you. That's what you're going to get, and that's what you're going to be stuck with. So there's a strategic thinking to dealing with ambiguities. And sometimes I'll look at it and say, look, this is ambiguous, but let's not touch it, because I know what's going to happen if we go back and try and clarify it. Let's leave it ambiguous. And if you leave and this comes up, here's the argument we're going to make. We may win, we may lose, but we have an argument. Where if we go clarify it now, we're going to kill that argument before we get off to the start. So I'm going to leave you with that thought. There's a lot of strategy, a lot of experience, a lot of thinking that goes into this besides just the terms that are on a document. And hopefully you take that away today. Any other questions for today?
No other questions.
All right. If I didn't cover something, folks, and you want to talk, shoot me an email. I appreciate it. Have a great rest of your day.